Briefly introduce the panelists. I'm Jill Manny from NYU Law School, and I'll introduce the panelists in alphabetical order, starting with Kim Eney. And Kim is a partner in the Exempt Organizations Department of Morgan, Lewis & Bockius, resident in San Francisco at this point. And the most important thing for me about Kim was that she was my student and research assistant when she was at NYU Law School. Drew Porter, the Associate General Counsel at the Bill and Melinda Gates Foundation, is also joining us. And Elizabeth Peters, General Counsel at the Hewlett Foundation. And finally, Rob Wexler, who's a principal at Adler & Colvin and works with a lot of foundations engaged in the advocacy space. So that's the panelists. I also want to thank Alice for setting up this amazing conference and for inviting all of us to participate. So we are going to start with Kim. And Kim's going to talk to us about, she's going to set the legal framework for us, focusing both on what legal restrictions potentially hinder advocacy by private foundations and the exceptions to those restrictions that make it possible for foundations to proceed with advocacy. So take it away, Kim.
Thanks, Jill. And I'm really going to focus on a high level because I think really the conversation and the discussion that will be had with Liz and Drew and Rob will be more informative in terms of how these legal constraints and considerations work. But to start, we thought we'd start with the definition of what is advocacy. And there's an organization called the Alliance for Justice, which really focuses on educating nonprofits around how to engage in advocacy. They have a bolder advocacy campaign. So I thought I'd look to their definition of advocacy. And they define advocacy as public support for or recommendation of a particular cause or policy. And so it's a really broad term. And for a long time, I think in the tax-exempt organization space, there was thought that lobbying was synonymous with advocacy, but that really has changed, and it's very clear that that's not the case. And advocacy is a much broader term that encompasses a variety of activities that are really focused on supporting, advancing an organization's cause or mission, and that can involve lobbying, but it's not only lobbying. And as we'll talk about more, certainly what is and isn't, like lobbying is fairly narrowly defined. I mean, it's defined in a manner that's consistent with what we'd expect, but there are a variety of exceptions and nuances to the definition that really allow foundations, 501c3 organizations to engage in a broad range of activities that are ultimately focused on advancing their cause and their mission. And certainly that in and of itself is consistent with 501c3 purposes. Jill mentioned I was a student in her course, and one of the things I remember her talking about is really so many 501c3s have educational purposes, and certainly that would include foundations and other philanthropic organizations, and it may be that they're advancing education through funding organizations that are doing that work, but so oftentimes that coincides with what a 501c3 is doing. So advocacy really kind of at the broader level is a core part of what it means to be a 501c3 organization. Stepping away from that and looking at the specific definition of lobbying, and the reason we do that is because there's a restriction on lobbying, and there's a restriction on lobbying by all kinds of 501c3 organizations. 501c3 organizations are divided into this world of foundations and charities, and I won't go into the weeds on that, but generally speaking, there is a distinction between the two types of 501c3 organizations, and charities can engage in some lobbying, but it can't be a substantial part of what they do. Foundations can't engage in any lobbying at all. So we care about what is and isn't lobbying for both types of organizations, but we especially care about it for foundations because they're subject to a tax for any expenditure that would constitute lobbying. So when we're looking at what is lobbying, I mentioned it's sort of what you'd expect. We're looking, and the code and the Treasury regulations define it. Generally speaking, we're looking at attempts to influence legislation. There's this distinction between direct and grassroots lobbying. Direct lobbying means making an attempt to influence legislation by communicating directly with members of a legislative body or with certain government officials or employees who may participate in the legislation. And then there are specific aspects of the definition that we look at to determine that a communication is lobbying. So we look at who, in the case of direct lobbying, we're looking at the fact that the communication is made to the legislative body. We're also looking at what the communication says, and it needs to refer to specific legislation, and it also needs to reflect a view on that legislation. We also have grassroots lobbying under the code and the regulations, and there we're not focused on direct communications with legislative bodies. Instead, we're looking at influencing members of the public to communicate with legislative bodies, again, as you'd expect. And then when we're looking at the communications, we still care about whether that communication reflects a view on that legislation, and it also refers to specific legislation, but it also needs to include a call to action in order to actually constitute a lobbying communication. So as lawyers, and Rob and I are both lawyers at firms that are advising charitable organizations, part of the first step is when we're looking at a communication, we're looking at whether it really is a communication that constitutes lobbying. So you can imagine there may be a communication that's directed to a member of a legislative body, but it doesn't refer to specific legislation and therefore wouldn't be direct lobbying. So there are a number of nuances, and I know that my co-panelists will talk more about those, but those nuances exist just with the very fact of the definition of what is and isn't lobbying. Then in addition to that, there are very specific exceptions under the code and the regulations that an organization can do. And the code and the regulations say that this isn't lobbying. So, and those include nonpartisan analysis and research. And I won't go into all of the nuances associated with that. It's generally what it suggests. You're looking at objective facts and a relatively objective position. Although you can advocate for a particular side, the underlying analysis still needs to be presented like a full and fair exposition of the facts. There's also an exception for technical advice. There are specifics around that exception. It needs to come, there needs to be a written request from a legislative body or a committee. So the request can't come from an individual legislator. It can't come in oral form. It needs to be in writing. But generally speaking, there's a recognition that charitable organizations have expertise. They're really engaged in particular areas of work that could really be informative to the work of Congress and legislators. And so this technical advice exception allows them to engage in communications and to lend their expertise to legislation. There's also a self-defense exception that allows foundations and charities to engage in lobbying when there's legislation that impacts their tax-exempt status, their duties, really the core of what makes their legal structure. So it's fairly narrowly defined so that it's not as though any type of legislation really qualifies for the self-defense exception. So if it's a piece of legislation that runs contrary to the organization's mission, that's not something that would qualify. But if it's legislation that's saying deductions are no longer going to be tax deductible, that would. So it's really looking at kind of the powers, duties, existence of the organization. There's also an exception for broad examinations of social issues. There's also an exception in the case of foundations for jointly funded projects with governmental entities. And so there is that possibility as well. Again, nuances associated with it, but foundations can fund projects with governmental entities. They can also make grants that require matching appropriations with the government. So there are just a number of different exceptions that come into play, really for all types of charitable organizations, including foundations, particularly when they're engaged directly in advocacy that may or may not constitute lobbying. Then with foundations, there's a recognition that, in this world of charities and foundations, charities rely on support from foundations, and they need to get funding from foundations, and they can lobby. So the code and the regulations do allow foundations to make grants to charities that lobby under certain circumstances. There's an opportunity for foundations to make general operating support grants to charities that lobby. There's an opportunity for charities to make a lobbying election. And even if that charity has made a lobbying election and is very clearly going to lobby, it's okay for the foundation to provide funding to that charity, so long as it's a general operating support grant. But even if the foundation doesn't want to make a general operating support grant, it can make a project grant to a charity that engages lobbying, even if it's clear that some lobbying might be included as part of the project. And there's this special rule that this project grant rule that really requires the foundation to take a look at the budget of the charity and ensure that the foundation's funding and the aggregate for that project doesn't exceed the non-lobbying portion of the budget. And so that's another way that foundations can support charities that are engaged in advocacy, and even charities that are engaged in lobbying, so long as not all of what's being done in connection with that project is lobbying. So I will stop there, but that's kind of high level overview of how these rules work.
Okay, and I'll take from there. And I think a lot of times,
I just want to talk for a second about the fact that you're going to talk about the practical aspects of advocacy by foundations based on your experience at the Gates Foundation. And I hope you'll also talk a little bit about policy here and whether private foundations should be allowed to advocate and why their voice might or might not be important in shaping policy. So
Thanks, Bill.
sorry, I was muted.
Okay,
That's
exactly what I'd love to talk about, because I feel so strongly that foundations oftentimes, when a foundation gets set up, it's motivated by a desire to invest in new technologies or human services, and I think it's kind of human nature that foundation managers may not want to get too deep in the mud of government relations and lobbying and all these things that we kind of instinctively feel a little uncomfortable about. But and you've got a West Coast panel here, and traditionally, I think the tech sector in the West Coast has a reputation of not wanting to engage too much in flying to DC and talking to people inside the Beltway. But I think my main point I'd want to make is just how important it is and how critical it is that foundations really do engage in the policy debates of the day. And as they think about their charitable work, they really make a point to understand the compliance burden that comes with these lobbying rules, which can be scary. I mean, we just listened to 10 minutes of rules and tax law, and it can seem quite confusing and really deter folks. But most of what Kim talked about, I mean, I think like 80% was exceptions, right? And it turns out that there are so many ways in which foundations can and should achieve their mission alongside government partners and participating in those really important discussions. And I think the Gates Foundation is a perfect case study of this. And I wasn't at the foundation when it was first set up, but as I understand it, our sort of global health mission initially had a business plan of maybe a half dozen folks who would review grant proposals and write checks to universities to create exciting new vaccines and medical interventions, and then great things would happen. And that was sort of the sort of plan A of that part of the Gates Foundation. And as you may know, we're more than 6 people now. We're quite large and have kind of a global footprint. And it didn't happen overnight, but the learning process, which is, hopefully other foundations figured this out more quickly than we did, was that we realized that to be successful, and if we were able to sort of nurture new medical interventions or other things, that they weren't just going to suddenly appear in Rwanda or find their way into the arms of people around the world, and we needed to work with government partners to prepare an infrastructure for vaccine delivery and make sure there were financial resources available to support these things. And also we just learned a lot, right? We were working with grantees and we were learning what worked and what interventions didn't work. And it didn't make a ton of sense just to keep that in our files. And so over time, we developed a pretty robust policy and advocacy function that works deeply embedded in our strategies to get the word out and to provide best practices and to make sure that people are as excited as we are about making sure, every life has equal value and that we can do the global health things and global development things we want to do. So, I'll talk in a bit about how we've done that and how we've kind of operationalized that. But I will say, just to finish with my advocacy, if you will, in the global health area, we've seen over the last few decades just enormous successes. I don't think it's a story that's been adequately told, but we've seen globally maternal mortality is like half what it was in the 90s, and preventable infant mortality is also way down, and the Millennium Development Goal and Sustainable Development Goal metrics are amazing. And I think there's so many people who get sort of credit for those successes, but I think advocacy is a huge part of it. I mean, again, I don't think vaccines find their ways into arms on their own. And so that's what's happening. And I think for us, and this relates to what Kim said, as we think about the work we're doing and foundations generally, I think there's a real discomfort in the idea of doing lobbying. It's prohibited. Nobody thinks of lobbying as an inherently charitable activity. And we work really hard to proactively make the distinction between good sort of educational work, working with partners, doing issue and policy advocacy, and using exceptions from the lobbying rules where appropriate. But if you'd ask anybody at our foundation or in the sector, they would say, no, we do not lobby. We cannot lobby, and lobbying is inherently bad, right? And I do spend a fair amount of time in training, and not just training internal staff at the foundation to make sure that we're all being compliant with these rules, but when we fund other partners, they have to be aware that our funding does come with these fairly complex restrictions, sort of handcuffs that are attached to our funding, that are embedded in our grant agreement and that they need to really follow and understand. And along with providing the technical advice and the support that they need along the lines of what Kim said, I often find in different cultures and legal situations that people just want to understand, like, why are these rules the way they are? They don't seem to make sense and they're not coherent. And why can we do some things that look like lobbying and other things that we can't do are also, somewhat similar. And I have to say, it's really an interesting question. And I've struggled over time to find the sort of the unified theory of US tax regulation on lobbying. And if you go back 50 years ago to when these rules were put in place, it's really confusing because the legislative history is full of stories of senators really worrying about foundations getting involved in policy debates, which we know are perfectly legal, right? Like the Ford Foundation's trying to desegregate schools. Some people didn't like that, and so on and so forth. And the laws that came out of that, they seem so broad. They say, foundations may not engage in any propaganda, full stop. But then they sort of define propaganda as meaning attempting legislation. And by the time they'd sort of written the laws and the rules, you see they actually restricted pretty narrow body of things that we can do. And I think that reflects the recognition that foundations have tremendous expertise and absolutely should be a part of public dialogue and debate and can support governments in so many different ways. And one final thing I'll say on this idea of whether lobbying is charitable or not is we do a lot of women's health work at the Gates Foundation, and people we work with around the world sometimes appreciate that probably the first major legal case that's like almost a century ago that really tried to come up with some rules here is it's a Judge Learned Hand decision around the Margaret Sanger's organization, which became Planned Parenthood, where Judge Learned Hand was really, really convinced that charitable money shouldn't go to lobbying to allow unmarried women to have access to contraceptives. And I don't think he did a really good job of explaining why, but the solution he came up with, which still kind of lives in the law, was that if you're a hospital or a university and you're doing good charitable active work directly for your target populations, it's fine to use that hook to lobby for appropriations or whatever. But if you're, sort of just an advocacy organization and you're just, out there trying to change laws, then that's something inherently not charitable about that. And I think that sort of lives on in how we think about the foundation work, and that really the advocacy we do, it should be somehow baked into our charitable mission in a really clear way. And that's what the rules kind of represent. So to bring that more practically to how the Gates Foundation has developed in its approach to policy and advocacy, we do have a separate policy and advocacy team that's present in our U.S. offices as well as in our regional offices, both in sort of donor countries in Europe as well as in our sub-Saharan African locations. And it works absolutely hand in hand and is really embedded in our strategic program areas. And it will both have a direct function of working with government partners to raise awareness and share information and collaborate on our programmatic objectives, and also has a pretty large grant portfolio working with think tanks, NGOs, various organizations to make sure that they have the resources they need to work with governments and to share with their findings and their priorities in various ways. And I'll give one example that I think is quite indicative of how that works. Is we work quite a bit with the Global Health Multilateral Organizations, the Gavi Alliance, and the Global Fund on AIDS, tuberculosis, and malaria. And these are organizations that take in tremendous funding from government partners and the Gates Foundation and other private sector organizations to procure vaccines and provide other services for a list of countries around the world. And I think a traditional lobbying approach to this kind of work would be to, hire lobbyists and sort of descend on DC or Berlin around budget season and try to push for more appropriations for these organizations because that's the way to get money where you want it. But I don't think that's how private foundations are supposed to operate, and that's certainly not what we do. What we do is much more long-term, and it involves really working with our government partners, sharing information, educating them in this sort of issue advocacy, policy advocacy way that's most appropriate for foundations, so that so that next year and 5 years from now, there'll be those champions in place and that awareness at the government level that these are priorities, so that appropriators and other policymakers will, on their own, come to the right legislative decisions in most cases and have the access to the expertise that we're able to provide, and take it for what they think it's worth as they consider decisions. It's also a great example of how some of the lobbying exceptions can be used, because as we work in the long term to help support these global health institutions, we're doing a lot of modeling and a lot of research to understand their impact, and a lot of that sort of data-driven analysis can be converted into white papers and presentations that fit within the nonpartisan analysis exception. We're co-funding a lot of these projects, so sometimes we're working with governments and sharing data about what our co-funded projects need, which might otherwise look like lobbying. And of course, many of these governments come to look to us or our grantees for help, and might, in writing, ask us for technical assistance in a way that would allow us to provide legislative input consistent with the exceptions. So, so this all, would require a certain number of lawyers and grants managers and a compliance burden that's not insignificant. And that includes the training of our staff and regular convenings with advocacy grantees and reviewing proposals and reports to make sure that everybody's doing things consistent. And we would never solely fund advocacy in this area, because we know there will be some activities that other folks would need to support or they need to have flexible funding for due to these rules. But we find it to be, a huge return on investment and absolutely an integral part of the work that we do. There are times when the foundation has to step back and say, no, we can't we can't get involved in something because of the lobbying rules, but I find they're pretty rare. I mean, maybe there's like a last minute budget snafu, or a governor wants to nominate somebody to a cabinet level position and we'd have opinions, but we can't get involved. And that does happen. We sometimes have new staff who will come in, and maybe from the private sector or from a lobbying firm, who just express real concern that their hands are tied and that you really can't do what we need to do through foundation mechanisms. And we need to have a separate 501c4 to do this kind of work. And to be honest, I haven't found that to be the case. I think it can be more work to do it right. And the foundation structure does require a certain level of rigor and caution. But I personally, and I guess maybe I'm a little biased in this, think that the results are worth the effort, because, coming at it from a 501c3 perspective, a charitable perspective, and rooting it in these processes, I think gives it an extra layer of credibility that it may not otherwise have.
Thanks, Drew. I was just going to ask you about this question of the 501c4, and we're just being aware of time, so just a minute or two. But I know that Bill and Melinda Gates set up a C4 that's separate but somehow affiliated with the foundation. And 501c4s are not restricted as to lobbying. They can engage in unlimited lobbying activity. And you said that I know that Gates has a 501c4. Are there any particular activities that you carry out within the C4, or have you found it not to be particularly useful?
Yeah, I mean, and we'll see what the future brings, but my understanding is to date that Bill and Melinda's 501c4 has been relatively inactive, and we have a very robust policy and advocacy team at the foundation that seems to do a good job communicating the issues we care about. But it is certainly another tool in the toolkit for advocacy.
Thanks. Mm-hmm. Thanks a lot. And we're going to turn to Liz now, and she's going to give us her perspective from the Hewlett Foundation, both the way that the Hewlett Foundation carries out its advocacy activities, and also address the policy question about whether it's important for foundations to engage in advocacy and whether their voice is important in policy discussions.
Thanks, Jill and Drew and Kim. I'm going to pick up from where Drew left off as another in-house practitioner. But before I go into the specifics of the Hewlett Foundation, I just want to make one plug. Kim started it for Alliance for Justice. So I don't know who's on our call today, but many folks who run their own charities or employees there may not have a dedicated in-house legal department. That's certainly my experience with many of our grantees. And so what do they do about some of this nuance? And if you can do advocacy, I think sometimes people are held back just because they don't have the legal technical support. And Alliance for Justice does do that. And they do have a free, I think it's like a 1-800 phone number you can find on their website. Or you can obviously call Rob or Kim. But if you don't have a lot of money, they're great. So I always like to plug that. Plus, I'm going to take one moment for those of you on the call that actually the Gates Foundation, along with Hewlett and the Packard and the Moore Foundation, put together an online free training course. You can find it at learnfoundationlaw.org. And so if you want the overview Kim gave, if you can't remember it, it was a fantastic overview, but if you need a refresher, they're like 20-minute, half an hour online courses that are freely available for staff to take. And we have both courses on how foundations rules work, but also how the charities rules work. So that's the thing I want to make sure we really focus on, is there are different rules for folks at private foundations like the Hewlett and Gates Foundations as opposed to public charities. So why this is really important is, as Kim noted, most of the partners of a private foundation are public charities. Not all of them, but most of them are. That's how many non-operating foundations, or we don't operate, at least at the Hewlett Foundation, we really give money and other people operate. So I think that's an important conceptual framework. I think the Gates Foundation has many more staff and do some more direct operations, but at Hewlett, we have a very lean staffing model. So as a conceptual basis, we're really effectuating our work in the world through our grantee partners. And so why that's important is it is legal for our grantee partners to lobby. So I just want everyone who's a public charity, you can, there's some limits, but you can, but the private foundations can't earmark our funds for lobbying. So I think it's really important to get that distinction, because it means that when you apply to private foundations for funding or you use foundation funding, we just have to be careful about how it's set up. But it doesn't say that you can't lobby. And so Kim pointed out, and I just thought I'd talk through a little bit about some of the key techniques if advocacy is an important strategy for your foundation or your charity, about how does that work. So I think a huge one that many people forget, and Kim mentioned it, but I just really want to bring it to the forefront of people's mind, is general operating support. So the Hewlett Foundation, one way we get our advocacy done is through our grantee partners with general operating support grants. So we give about 30 or 40% of our grants through general operating support. That means a charity can do whatever they want with it, and they can lobby with that money. There's a clear exception. So if I give money at the Hewlett Foundation to, I think we were talking about Planned Parenthood, Drew mentioned, and Planned Parenthood thinks there's an important issue on women's health that involves legislation, as long as our staff at the Hewlett Foundation doesn't tell them to do it, talk to about what the legislation to say, be on the lobbying calls, right? We just have to step out. They are welcome to spend that money on lobbying. So I think that's a really important distinction that many people forget, right? And it is a way, if you believe in advocacy in the foundation space, that if you can give up control for your own staff, right? You have to let go of control and trust your partners, the public charity grantees, they can lobby with that money. And that really does help create more space in the field for advocacy to occur. So that's one very easy, and it doesn't require lawyers, I should say. It's pretty easy as long as you can train employees at the foundation that they are not allowed to participate in those decisions. And so I just highlight that as one strategy. And for foundations who have a philosophy of general operating support, it is a very effective strategy to get advocacy on the ground. And I think an appropriate one, because as a private foundation, you're not actually controlling the message, right? You're allowing public charities who are broadly supported by the public. And I think I always have understood, we were talking about the policy question, why do foundations have a different rule than charities? The way I explain it to our team internally is I think originally I'd always understood it as a pro-democratic rule, which is public charities, to be one, and Kim didn't go into the technical stuff, but at a high level, you basically have to be broadly supported by lots of people, which means you're kind of a pro-democratic institution. And you might have different views, you're gonna have groups that aren't all the same, but it has to be a significant number of people. They're allowed to lobby because it's important to hear, different groups of voices in a democracy. Why private foundations were restricted is really what makes a private foundation is you're from one donor or a small group of donors, a family of donors. Was maybe it wasn't appropriate to take a tax deduction. Of course, they can lobby without the tax deduction in a C4 or in a for-profit or in their own personal checkbook, but maybe not to provide a tax deduction for that group to lobby. So anyway, this is how I've always thought about the rules, which is why if the foundation gives the money and doesn't tell the grantees what to do, they can of course lobby because they themselves are supported by many people and have a sort of more democracy stance. So that's the sort of public policy and rationale for these rules that I've always understood kind of underlies all of this and why it makes sense that general operating support would work. So that's one area I always like to highlight. As Kim talked about, another, if we talk about just grant structures, is the project grant rule. And I think this is probably the least understood technique in my experience working with a lot of grantees. I'm not big grantees, very big grantees who do a lot of advocacy work, I think understand this, but smaller groups who are getting into it or have never done it before, who've never asked for foundation funding. And it's just this idea, basically, that there's other money in the project to support the lobbying component, and the foundation can support essentially the non-lobbying component of the project. But you can still put it all together. You can still put one proposal together. We just need a budget that allocates out how much is lobbying and how much is non-lobbying, and cover the non-lobbying expenses. And typically, and I think Drew did highlight this, because the lobbying rules are so narrowly drafted, a huge amount of an advocacy project typically does not qualify under the legal definition of lobbying. So I think that's always something really important. And like I said, Alliance for Justice, among others, can walk through how that works and how those allocations would set up if you're on the call and you don't know how to do that. So that I think is two key ways that you can think about as a foundation, helping support advocacy. And then I'd also like to talk a little bit about what isn't included in the definitions, because I think this is really critical, which is regulations and regulatory policy. So as Kim highlighted, it's about legislation. So at least in the modern United States government, a lot of public policy is regulatory. And in fact, sometimes more of it's regulatory than legislative, right? They leave a lot of the details to the regulations. Those regulations are hugely important. So I'll give an example. At the Hewlett Foundation, probably one of our largest programs by dollars is climate change, is helping to stop climate change. There's actually a huge amount of work that can be done through regulations. Again, I'll give an example from California, and that's where we're located. California has some of the strictest regulatory rules on miles per gallon emission standards for automobiles in the United States. California is the largest market for purchasing cars. So if California says you have to give higher mile per gallon cars, you're going to have a much more efficient and less air pollution. And you don't need to go talk about legislation. And if the Congress doesn't want to change the Clean Air Act or other sorts of legislative rules to make a policy change, there's a lot that can be done at the regulations level, which is legal. And there's no restriction on private foundations funding grantees who want to do regulatory work. So I think that's also a huge gap that I think, if you just ask the average citizen, what is lobbying? I think you would think most people would say it's regulations and legislation, but that's not how these rules have been drafted. So I think that's a really important nuance for people on the call if you're interested in doing advocacy work or applying for foundation funding for that work. The one thing I'd highlight that we haven't talked to today, because Kim really talked about the federal tax rules for charities, is that states have rules on lobbying, including registration rules. So the one thing I did want to highlight today, if you're actually going to practice this, is understanding if you're doing state regulatory work that you may have a disclosure requirement. So it's not illegal to do it, but you do have to disclose it. And that's certainly the case in the state of California. So one thing we work on at the Hewlett Foundation, we do fund work doing regulatory policy, is also checking in the states that we work in the United States on what the obligations are to file. So we have been a filer for many years in the state of California for the regulatory work we do in the state. So you can, and what that means is you can look it up and you can see what it is and how much we funded and which grantees we funded that did that work. So I think that's an important aspect too, is some of the transparency around that. So foundations are doing it, just understanding where they are spending their money. So I wanted to highlight a couple of those because they can be quite effective to work on regulations. The other thing I thought I'd talk about, if we talk about exceptions for another minute or two, is nonpartisan analysis and research, which Drew talked about. How we think about that, using that a lot, is many of our key grantee partners are universities or think tanks in the policy space. So we fund people like the Brookings Institute, Aspen, Center for American Progress, much of the UC system. And many of those folks are actually working on research reports about how legislation could actually make lives better. But they're doing it, as Drew noted, with a lot of data and analysis or research studies behind what would be the best choice. And so as I always tell people, especially when you're working with kind of I would call them like a blue chip grantee, someone who's considered a think tank or a university whose whole business is essentially, talking about pros and cons of an issue, it's much easier to do this type of work. And the report at the end can come to a conclusion on specific legislation with actually a viewpoint on it, which would be lobbying. But it isn't, because it's one of these exceptions, because the whole point is the research piece is supposed to talk about the pros and cons. Like, here's why we thought about it, here's you could do it this way, or this way, or this way, and option 2 is the best, and here's the pros and cons and why I think that way. Again, this is an exception I think that many people who work a lot with think tanks and universities use. Where it doesn't work well, and occasionally we see people ask us for money here, and as Drew noted, it is important to have a compliance infrastructure. We wouldn't fund something like this, is that my 2-pager that I'm going to walk in on Capitol Hill is nonpartisan analysis and research. It's not. I had a general counsel I know tells her team it has to have a thunk test. Like, if it doesn't hit the table and make a thunk, it's not nonpartisan analysis and research. It's got to be thick, it's got to be weighty. So I think that's a really important, though, tool, because, and one that I think is appropriate, right? Because those types of reports do give legislators or their staff a whole bunch of credible research and options on all sides. And they may come to a point of view, but obviously those people are smart who are reading it, and they can read the whole report, and they could come to a different view because they have the underlying research and data to decide it. So I think that's a very important way foundations can fund a lot of thoughtful scientific research or other types of research that helps answer questions that maybe government doesn't have the funding to do on their own. I think that sounds like some of the stuff that the Gates Foundation is doing. And then the other one we talked a little bit about as an exception is the written technical advice exception. So this is, again, as Kim said, this is always an interesting exception. We have received these from time to time at the Hewlett Foundation, where we've received a written request from either a congressional body or from a state legislature, from the head of the state legislature usually. You need it, as she said, not from just any member of the legislature, but from the head of the committee or the head of the legislature, to ask about the viewpoints on legislation. And this is when actually foundation staff can specifically essentially lobby, right? It's an exception to the lobbying rules. They could go in and help them write the legislation. So an example of this is we've had a long-term program on open educational resources. These are free resources. Hopefully you've got some Yale students on today to help bring down the cost of textbooks, right? That's a very expensive market. It prohibits many people from learning. You also can't rewrite them and adapt them to culturally relevant students, for example, or culturally relevant experiences. So taking a science textbook that's openly licensed and free to a school district, and it allows their teachers to say, if I live in a desert climate, I can make the science discussion about deserts, and here I can retake it and put it in a different type of climate environment for someone else, or I can make it appropriate to changing out who the people are. So if our population is largely Latino, I can make the experience a Latino experience so that my learners can see themselves in the materials. Or if I have a different type of population, I can change it there. So anyway, these are the concept of open educational resources. And we've, for many years, been one of the key funders in this space, as well as having some of the field's technical experts actually on our staff. So there was a time when the California legislature was considering enacting legislation to require some of their state universities to use more open educational resources to save them money and save students money. And they actually asked our staff member to come up and testify and give some advice on this. And obviously we got a written technical assistance letter. And it was the one time I told them they could forget all the rules I had taught them. For all the rules, they could say whatever they wanted. So those are not easy to get. It's not a common exception, but it's a very powerful one if your institution really has a leading group of experts on a topic. And you can also ask, sometimes the government people don't know this exception exists. So I would say, if this is something that you're interested in doing, you should tell them about it. Sometimes we have to. They'll call us and I say, I'm so sorry. We would love to participate, but I have these rules and I want to respect them. And therefore, here's what I need instead. Can you do this? And then we can participate. I found there's actually generally a fair amount of openness to the other side. They just are unaware. And of course, why would they? They're not a private foundation about these rules. So that's a brief overview. I think that's about my time. So back to you, Jill.
Thank you so much, Liz. And we're going to turn now to Rob. And Rob's going to, Rob represents a number of foundations, a fairly vast number of foundations, but he's going to focus, I think, his discussion on certain issues that his foundation clients have faced in trying to advocate in the area of racial justice and equity. So take it away, Rob. And then we're going to come back to Kim for a few minutes to talk about international grant making, international advocacy.
Yeah, thanks, Jill. I just wanted to, so batting cleanup here and having heard what everyone else has said, I also just want to drive, before I get to the specific client example, I just wanted to drive home. I love what Liz said about the two key ways in which private foundations can really impact. And one is general support grants, and one is a specific project grants. And I just wanted to give a specific example just to really drive home the specific project grant, which is that literally you could have a grantee come in with $1 million grant proposal, and 500,000 of that could be lobbying. And the Gates Foundation and the Hewlett Foundation could each make a $500,000 grant to that grantee. And even though 500,000 is non-lobbying and 500,000 is lobbying, that would work under that proposal, as long as neither of them earmark their grant for the lobbying portion of it, and each put in their grant agreement that their grant was not earmarked for lobbying, and some other little hoops were jumped through. So it's really a very flexible provision in the regulations and very usable. And it's really a good tool that we all have to work with, assuming you do it right. As to general support grants, that's where my clients have been working very actively, particularly in the last couple of years, to address a key issue that's come up, which is the Black Lives Matter movement, particularly in wake of the George Floyd incident and other incidents that have evolved. And I want to give one example in particular, but There's also, this has coincided with another movement that's evolved called, I think it's sort of referred to as trust-based philanthropy, which is sort of this avant-garde. I think it's mostly a West Coast sort of thing where you give general support grants, you do your investigation up front into the grantee, and then you give them money and you let them run with it, and you don't really require a tremendous amount of reporting, and you give a very sort of lightweight grant agreement up front, basically letting them run with it. You trust them, in other words. So one of my clients, I have several clients that have, more than several clients that have been funding in this area, but one example of using public charities that you trust and letting them run with this and doing advocacy, and having advocacy being the result of this, even though the private foundation is not directly engaging in advocacy or lobbying directly, which they're not allowed to do. I have a client called the Libra Foundation, and I know that Hewlett was one of the funders of this Democracy Frontlines Fund project, where 12 funders, the Libra Foundation put together 12 funders, each gave about $3 million to fund 10 grantees. There was a fund put together at a public charity. It was really a very trust-based project where a brain trust of 10 leaders, Black and brown leaders, came together to identify 10 grantees who were working in the space. And the private foundations, including Libra and Hewlett and some others, put their money in. And some amazing work came out of this in a time when it was really necessary. And a lot of the work would be considered advocacy. Now, again, Kim's definition of advocacy, I think, is important because it includes direct lobbying. And as part of this, there were some bills that actually were supported out of this. But it also includes regulatory work. As Liz mentioned, there's regulatory work that comes out of this. But advocacy is much broader than this, right? Because advocacy also includes public awareness. It includes public education. For example, I was looking at the 1 year. So this was funded, for example, this particular initiative was funded in 2020. And I was looking back at the 1 year report. And I noticed that one of the organizations that was funded in this was the Black Futures Lab. And I noticed that in their report, they talked about everything from funding a vaccine education program, which would be really just advocacy in the general sense, not lobbying, to an actual assembly bill that they worked on, to educating the public about the filibuster and the budget reconciliation process. Well, some of that could be considered actual lobbying, and some of it, of course, wouldn't. There was another measure, Black Voter Capacity Building Institute, which did everything from launching freedom rides to encourage voting rights, to holding Making Good Trouble rally to encourage HR 1 and HR 4, which were the voting rights bills that I don't believe actually have gone anywhere, but nonetheless, still that would be considered actual lobbying. And this foundation and others like Hewlett have also engaged in climate change initiatives and other things. And so my point here is that so I work with a lot of what are now known as mid-sized foundations, unlike Hewlett and Packard. So mid-sized foundations these days are organizations with anything from 50 million to $1 billion. I know that seems unbelievable to call those mid-sized private foundations, but that's what they are these days. And they're very nimble, and they can move quickly and make these grants and these sort of general support grants to public charities. But as Liz and Drew pointed out, there's this tremendous ability to make these unrestricted general support grants. And the key is that you want to make sure in your grant agreement that you don't do what some foundations do by mistake, and they put in and not put in a clause in your agreement that says that you're prohibited from lobbying, because if you do that, you've really put a burden on your grantee that is untenable. What you want to do is put in your grant agreement a provision that says that this grant is not earmarked for lobbying. Now, obviously, if it's not a public charity grantee, you can't do that. But if it's a public charity 501c3, you put that provision in, and then they can go out and they can do basically, as Liz said, whatever they're allowed to do with the money under their public charity rules, which includes some amount of lobbying. So in the Democracy Frontlines Fund example, we had quite a bit of lobbying and non-lobbying activity. Much of it was considered advocacy, and I thought it was a very, very successful endeavor as just one example of what some of my clients are doing. So that's my spiel for today.
Thanks, Rob. Kim, back to you to talk a little bit about international advocacy.
Thank you. And thanks everyone else who's kind of filled in the details of the earlier overview. I don't think there's a lot to say here in terms of the international piece, except that it does apply. So engaging in grant making and having grantees abroad means that we still need to pay attention to those rules, and that foundations still need to ensure that their grantees that are doing work outside of the United States are not engaged in lobbying, and it becomes trickier. Certainly as a lawyer, trying to understand the nuances associated with the legislative systems in other countries. But it's an important part of, what we need to do as lawyers is ensure that that there is an understanding. And part of that too means, and to Liz's point earlier about the Alliance for Justice being an important resource, is that training grantees and ensuring that grantees have the resources that they need to understand the rules and how they work is an important part of ensuring that foundations can continue to support them. So that's all I'll say in terms of the international piece, is just that it's complicated, complex, and still requires us to pay attention to these rules. I thought also we also talked about 501c4s. Drew talked about the 501c4 with the Gates Foundation. And so I thought, since we're talking about philanthropy and advocacy, one thing we are seeing increasingly is that kind of starting at the very beginning with individuals who are deciding how to engage, how they want to engage in philanthropy, that sometimes the case that philanthropists are viewing that they don't want to set up a 501c3 private foundation, and instead, because part of what they want to do is have the flexibility to engage in some lobbying or support organizations that engage in lobbying, and not have to or not have to pay attention to all the nuances and the exceptions, regardless of the fact that they offer quite a bit of flexibility. There are some philanthropists who are just setting up a 501c4 and relying on other means to take the charitable contribution deduction, which is the advantage of setting up a 501c3 foundation. But you can get that really in doing and making contributions directly, or setting up a donor advised fund. And so in addition to 501c4s as affiliated entities of C3s, including possibly foundations, we're also seeing 501c4s really as a philanthropic tool that stands as an alternative to 501c3 foundations. So I thought I'd mention that as well.
Yeah, we're seeing that also, Jill. We have
Just going to ask.
Quite a few clients with wealthy donors, which will have they'll have the family office, and they'll have one or two donor advised funds, and they'll have the private foundation, and they'll have the 501c4, and they'll have maybe some other tools, and they'll use them each in their own place. The other thing I just wanted to say about international philanthropy, international lobbying, funny story was, we had advised one of our clients not to do a certain thing because it was lobbying private foundation, and one of our associates was happened to be taking a trip to a foreign country and happened to speak the language and was down there and saw a big billboard where our client had paid for it and was lobbying, and took a picture of it and came back and showed it to me. And I said, we got to tell them, and they said, how did you find out? And we said, well, we're everywhere, sorry. And so that.
Thanks, Rob. Just trying to get myself unmuted. Oh, Alice?